Hi everyone, thank you for joining us for this 9th Public Procurement Forum here in Frankfurt. Thank you, Jakob, for inviting us in your office and on your webinar platform. Hi to all the people that are joining us online. Hope you hear us loud and clear. Otherwise, you can always just chat. Well, we have quite a packed agenda this afternoon, but we'll try to keep it light and hopefully interesting. We will talk about various subjects. Maybe, Jakob, I don't know if you want to do a quick summary of our very interesting subjects.
Yes, thank you, Virginie, and also from my side, a warm welcome here in Frankfurt. It's a very international town, also hosting the European Central Bank. And so we are very happy to host this year the first time in Germany and in Frankfurt. Yeah, we'll have a very interesting program starting with ESG criteria in the public procurement process. And here we also have Ms. Natascha Graf from the European Central Bank as external speaker. Welcome. Then we have later on a workshop for do's and don'ts in the submitting process of offers. Here also we will have a look on the public procurement from the bidder's side. Afterwards we have a coffee break. Then we will have a look on recent highlights from the ECJ and practical takeaways for bidders. And lastly, we have the topic foreign subsidy regulation impact on EU bidder, all presented by CMS colleagues, which we can introduce later on.
So yeah, we try to have quite an international crowd of speakers. So we will have speakers from various CMS offices, and like we said, also one prestigious external speaker. The aim of these presentations was also to try to keep it quite practical for either bidders, mostly for bidders, but also for contracting authorities. We hope that you will enjoy it and that you will take some things with you back home back in your office. Right, shall we start with the first session? We will call maybe the panel of the first session to come here and to start their presentation. Thank you.
Yeah, thank you.
Thank you very much.
So let's start with the first topic, ESG criteria in the public procurement process. And I would do a small layout of the topic as a kind of introduction. And later on, Natascha will go in deep and show the practical way of doing it at the ECB. If we look at the main target of public procurement, of course, it was always best value for price. I think that's a key aspect, and it's basically the economic perspective of any procurement activity. However, during the 1990s, about ESG criteria became more important within general politics, but then also in procurement activities, and contracting authorities began to implement such criteria also in procurement procedures. And so it also became subject of legal disputes in how far this is admissible. And there was, for instance, one landmark decision by the European Court of Justice, Concordia Bus Finland, where such criteria have been acknowledged as admissible. Here it was about emission reduction rates for the procurement of buses. Later on, such ESG criteria have also been implemented then in the public procurement directives themselves. And so we find now, for example, environmental eligibility certificates in Article 62, or social and environmental criteria as award criteria in Article 67, or, for instance, the consideration of life cycle costs in Article 16.8 of the directive. So altogether, we have different approaches to implement ECG aspects. It's first work description itself or service conditions. You can, of course, implement that already here. Then you have it in selection criteria, for instance, the EMAS certificates. And last but not least, you can use it as award criteria. So you have a quite complex and comprehensive approach to consider such aspects. And altogether, you find here ESG criteria. Lastly, we also have to consider restrictions to apply such criteria as well. So, for instance, the ESG criteria may not just pursue any general political goal, but they always have to be interlinked with a specific procurement subject itself. You also find this written down in the directive. Then, of course, it must be done in an appropriate manner and shouldn't completely override all other aspects as quality and price. And then, and this was also held by the ECJ, the criteria must be in accordance with general principles of European Union law, in particular the principle of transparency and non-discrimination of tender participants. So starting from this, I am happy now to hand over to you, Natasha, and you will show how to do that in practice of the European Central Bank. Thank you.
Thank you very much. Can I give my presentation?
Yeah, it's just.
Okay.
Can you
Perfect.
go on with it? Huh?
So, my name is Natascha Graf. I'm a lead expert at the Central Procurement Division of the European Central Bank. I started working for EU institutions and more particularly in their public procurements in 2006. That makes quite a few years and quite a number of public procurement procedures which I conducted. And today I'm going to tell you a little bit about ESG, green and sustainable and social procurement at the ECB. Now, the ECB, to start with, is EMAS certified since 2010. EMAS certification is audited yearly, and every year our catalogue of measures relating to the certification, our policies, our projects, our objectives are reviewed. And this means that in order to keep this EMAS certification, our procurements need to be green, sustainable to a certain extent. Otherwise, we would not be able to fulfill the criteria that are set by these certifications. Now, the ECB, as an EU institution, is not subject to the EU Public Procurement Directive because that is addressed to member states, as you know, which means that the ECB has its own set of procurement rules set down in a procurement decision. But this decision is very, very largely conform with the EU directives. There are only minimal differences, and even these are sometimes to the detriment of the ECB because they are stricter. But in general, we are following what the directives say. Now, as I said, we have an environmental policy, we have objectives and measures following the EMAS certification. And every year we conduct around 170 competitive procurement procedures. Now, it can be more or less, it varies from year to year, but that is round about the number of competitions we have. We publish our tender procedures which with a value above the thresholds that you know in the official journal as well as on our website. We award mostly framework agreements because in our procurement rules, the maximum contract duration is kept at 4 years, both for direct contracts and framework agreements. And In that case, we think that framework agreements work better for us because they offer more flexibility. Our working language is English. So if you participate in any of our tender procedures, that would be in English. We expect that the bidders speak and submit all their offers in English language. And our contracts are in English language as well, but they are subject to German contract law. Now diving into ESG procurement. As Jakob has just said, our rules as well as the directives limit the scope of what we can apply. So obviously the selection and award criteria must be linked to the contract subject matter. We have no freedom to use any criteria we want, but the link must clearly be there. Once we have drafted our tender documents and specifically specifications and award criteria and offers have been submitted, then nothing can be changed anymore, even if at that stage we would find out that there is some much better way of describing the subject matter of the contract. It's no longer possible to change it. We must award to the most economically advantageous tender, meaning that price always has a relevance. And that means that it's not necessarily the greenest offer that will win. It may well be one which is less sustainable but has a much better price. And once the contract is signed, it can only be changed under certain conditions. The scope of amendment is also limited by our rules. Then also we find that the markets can be quite complicated in terms of green procurement. There are so many eco-labels, certifications, different ways of calculating CO2 footprints. The markets are changing very fast. The price fluctuations which we've had in the last years have been really a challenge for us. There are constantly innovations, etc. So a good market knowledge is something we must invest a lot of time in currently to prepare our tender procedures. Here's some examples of success stories. Starting with catering. Our catering is now almost totally plastic packaging free. We have reuse, refill packages. We eat seasonal and regional. Most of the food is purchased fair trade, etc. We have a meat-free Thursday, and we had little complaints, I must say, so that works very well. In our cleaning, we also have many green criteria. We have result-based cleaning. We have water recycling. We have mostly microbiological and green cleaning agents. We have daytime cleaning, very important for social aspects. So I know that in some countries like Belgium, this is normal. In Germany, it's rather not, or not yet. Many cleaning is done during the night. In terms of building facilities, we have filters to reduce water consumption. We have devices to reduce energy consumptions, etc. We buy only 100% green electricity and only biogas. We have a beautiful outdoor area, which is very sustainable, with lots of wildflowers, bees, etc. That is kept very ecological. We do, of course, waste separation and recycling, and textiles and flowers come only from bio and fair trade production. So these are a few examples. There are, of course, many more, but maybe these are the most visible. Now, here are some examples of criteria and requirements we used in past procurement procedures. For example, we asked that our consultants travel by train wherever travel time is less than 4 hours. We would not reimburse flight tickets. We ask that supplies are bundled in their deliveries. We prefer plastic-free packaging. Sometimes we ask for specific eco-labels. We ask that fair trade and ILO labor standards are applied down the supply chain. Sometimes where it makes sense, we ask for female staff to be present in the team. For instance, there are security guards there, we can reasonably justify this. Selection criteria is something we use less often because also, we would not like to reduce the market too much or exclude companies which are not operating green yet, but we would rather take them on the journey and change their behavior by together performing a contract that has green criteria. We do nevertheless sometimes use EMA certification as minimum selection criteria where it is relevant for us to keep our own certification. And sometimes we do ask for specific experience where we think this is necessary for the contract performance. As a what criteria, we often use environmental consent, where it makes sense, obviously, again. But we ask the bidders to develop a specific concept for the ECB that will make the delivery sustainable. We also, when we have contracts like cleaning, catering, where you have a large workforce, which is often paid minimum wages, we do ask our bidders to develop specific working conditions, which will ensure that the staff is motivated and retained. And this has paid off because currently in the German market, there is more demand than staff, also in the low-wage sector. And staff that has been deployed to the ECB so far is very happy and is staying with us or with the contractors. And so we might have fewer issues than other companies or institutions. Here, just to show you, these are the actual award criteria we used in our cleaning contract. And the ones in yellow are those where we use green criteria as well. Now, this is really only the overview with the headings. The bidders, of course, received much more extensive documentation. The criteria were explained in more detail, but there's just not enough place on this slide to show you everything. But in these green criteria, yellow mark criteria, green played a very important role. So you can see there is quite some importance attached, and it can make really a difference in the award of the contract. And this is just for information. This is the scoring methodology that we normally use at the ECB in more than 90% of our tender procedures. Oops. So you can also implement green in contract clauses. Obviously, a duty to comply with any environmental or social laws, but that should actually not be mentioned. For me, this is a given. You can implement a duty to systematically report and actively contribute to the ECB's EMA certification. This is something we regularly ask for. And then one clause which I love very much is reciprocal commitment to innovation. We do have in some contracts the clause that the contracting authority agrees to be used as test customer at no cost. And that, for example, was used when our cleaning service provider first tested his water recycling system at the ECB, which later on was fully implemented. We also have from time to time some robots running around, some biometrical access system tested, etc. So it also has a fun component, but I think it also supports innovation. And also we ask our contractors to regularly update us on improvement, innovation, etc., so that we are kept up to date and can together discuss whether improvement even within the existing contract is possible. Now there's also the possibility, obviously, to develop an SLA and to ask for minimum sustainability targets, which would be penalized if they are failed, or why not rewarded with a bonus if they are exceeded. It's also possible. And last but not least, we try to use functional requirements describing the outcome without describing the methods and the processes, so that there is more flexibility during the contract implementation to implement innovation within the limits of the procurement rules. So this is how we work at the ECB. I invite you to check our website. You will find loads and loads of information about green procurement at the ECB in there, and the projects that have been implemented, as well as the full EMAS reporting and data on what we achieved. Thank you very much. Would you have any questions?
Yeah, are there any questions maybe here in the audience for Natasha?
Yeah, maybe I can talk loud and it will be okay. Just in case. Thank you.
Thank you, Natasha. Thanks a lot for this interesting presentation. I find it often difficult to implement some ESG criteria, and especially environmental criteria in public procurement, because they are often linked to local products, or well, not always, of course, but it plays a role, of course. If you buy food that comes from Canada or the US or China, it costs more in terms of environmental impacts than buying local food. I saw in your presentation that you were talking about regional food, for example. I know in Belgium, when clients of us put some local or regional emphasis on their criteria, we tell them that there is a risk in doing that, because this could be a discrimination between EU countries and countries with whom the EU has agreements. So we try to avoid that, even if it makes sense, of course. Do you struggle with these questions as well at the ECB, or less?
Yes, obviously, these are questions we ask ourselves as well. And here, regarding the catering contract, the award was first of all, to a catering services supplier, and we only put into the contract others, but actually not. What we did is to ask them to tell us where they source their food from, and we would get extra point if it was sourced. I'm not sure we use the word locally, but sustainably for sure. And thereby, first of all, we were the main contract was about the service provision. The procurement of the service provider is only the next step. And by asking them to procure sustainably themselves, I think we were still within the boundaries. Yeah. But I can tell you about another case, which was the procurement of masks during the pandemic. As you know, in the beginning, all masks came from China, but later on, there were productions in Germany as well. And so when with the third batch of masks we procured, we inserted a CO2 footprint with the transportation. And we published the formula we would apply, which was publicly available. And so what we did at the award, we calculated the transportation footprint, and it was one of the award criteria. And so we were able to purchase masks produced in Germany.
Yeah, it's always quite a gray zone where you try to emphasize sustainable transportation, etc., but without discriminating to countries that would be located too far. Thank you.
Yeah.
Hi, Natasha. Thank you again for that presentation. I was just wondering whether you had experienced any sort of much pushback or resistance. So when you're introducing these requirements or the evaluation criteria, do you find bidders are resistant at all to them?
Not really, neither internally nor externally. Also within the ECB, sometimes you need to convince the contract managers to procure more green, but that works quite well. We even have a lot who themselves come forward and say, I want this to be a green procurement. And on the bidder side, I can't really say that we faced any pushbacks or criticism. Not more than in any other procedure for any other type of criteria. Put it that way.
Maybe connecting with this, I also want to know how is it specifically with small and mid-sized companies? Are they not maybe a bit overwhelmed, to write these concepts and so, or is that not a problem for you?
I don't think so, because the amount of information we ask from the bidders is always in relation to the size of the contract. So for a cleaning contract, which is multi-million, which is a big contract with a large employment, we will of course ask a lot of information in many different environmental concepts. Now, for a smaller contract, which is more attractive for smaller companies, we ask just one small environmental concept of half a page, 1 page. So it's always proportionate. We would not exaggerate in that sense.
Thanks as well from my side for that interesting presentation. I have a question on, you said, I noted that down labor standards down the supply chain. Now that can be quite challenging actually to find out, and question is how far do you go down the supply chain? What kind of evidence would you expect there, or what would the bidder have to come up with to convince you?
So it depends on the contract. We don't do that systematically. It really it was one criteria for suits, for example, where we purchased tailor-made, custom-made suits for our security guards and drivers and so on. And there we knew that the production of textile can be, when it's done in certain countries, which I will not name, can be done very often below labor standards. And there we asked for this. And we asked for certificates to prove literally from the farming of the cotton or of the wool, that even the sheep are treated correctly. So a certificate or different certificates from the whole production chain up to where we buy the product. But we would not do that systematically for any type of supplier. We do make choices there. Yeah.
And I guess in that example, you would expect a producer to actually know his supply chain because it's his actual business. Well, I believe it probably becomes more difficult when this, you have many products to deliver, and you would have it kind of, follow the entire supply chain for each and every product.
Absolutely. I would not do that for a catalog of office supplies with 2,000 items. That's not possible. So we really must make a difference there. Totally. Although now we have in Germany this Lieferkettengesetz, which obliges at least for some part and some suppliers to follow up their supply chain. That's very helpful as well.
Any more questions? Yes.
I have one question regarding the daytime cleaning you mentioned. Can you tell us, I don't really understand what is the reasoning behind such a criterion. I mean, bearing in mind that at least I think that the companies that apply for such a contract would employ people that would employ the people under legal working standards. So what is the reasoning behind that extra criteria?
It's simply because the workforce is happier. and it's a fact. So we did have a night cleaning for a very, very long time at the ECB, and the cleaning staff, which is composed mainly of women, let's face it, found it difficult to have a work-life balance and to organize themselves, the childcare, etc. And since we switched to daytime cleaning, when the cleaning personnel comes in at office hours and leaves during office hours, we receive a lot of feedback from the cleaning personnel saying we are much happier now. We can organize ourselves much better. I can take care of my children. I can organize myself. Thank you for allowing me to work during day instead of night. That's all.
Thank you.
Any more questions here in the room or from the outside? You are welcome to send us also questions with the Q&A mode.
Absolutely. Feel free to stay in touch. I'm on LinkedIn, and you know how to reach me at the ECB as well. So thank you very much. Looking forward to more discussions with you during the day.
So I think we just move on with the do's and don'ts of submitting a successful bid. Here, Margot Christian, my partner from Switzerland, is so nice to moderate this workshop a little bit. And also Julia Haas and Volker Storb will join myself, and we will present it here now. So welcome here, and I would then just hand over to Mark.
Thank you, Jakob, also for hosting us here and for having us here. I'll come over here. We'll start with thank you very much. So thanks. Let me go back a bit. So yeah, so the next panel would be on do's and don'ts of submitting a successful bid. So you hopefully practical tips for everyone listening here on how to succeed in any kind of tenders. The first part will be a bit on, I would say, EU-based, which makes sense, with mentioning a few particularities, especially from a German perspective, I understand. And then the second part, we will have an example of a non-EU country, surprise, surprise, Switzerland, and have some particularities from that perspective, showing you a bit that it is really important to pay attention to the specificities, and it can be the small details that can make the difference, especially in the very formal tender procedures as we know them. Now, I won't go through the entire list of topics because I will leave that to everyone else. Just a couple of words on the presenters. Jakob, you know him. He's the co-moderator here and partner here in Frankfurt, and keeps sitting here for a while, and he seems to enjoy the spotlight. Then we have a young and talented procurement lawyer from Amsterdam, Jakob Schneif, who will then do the second part in the beginning, and then Julia from my team in Switzerland, who will then do the Swiss. Volker, sorry, what did I say? Sorry, I was confused. Sorry. Jakob, of course, then Volker, who is from the Amsterdam office, and then finally we have Julia from my team in Switzerland. Sorry for the confusion. We've just met online so far, so it's good to see you here. Then I would say we go through the topics here. As I said, I won't go into the details here. So Jakob will start now with the first part, which is rather kind of starting at the very beginning. The idea of this presentation is a bit to actually take you through the whole process and then point out some things you should pay attention to while participating or preparing for it a bit. So over to you, and then you'll take it from here. Thank you very much, Jakob.
Thank you, Mark. So yeah, as you see here, maybe we can just have a short look on the agenda. We will start with bidding organization and management, which is quite important, even though it's not merely a legal point. Then we have formal requirements for the bid. We have the third point, optimizing the contents and winning chances of the bid, which is very important. In fact, we have the aspect of the right communication with the contracting authority, which is also quite important. We should, of course, as a bidder, uphold compliance rules, which we will go into it briefly. And then we have the particularities of non-EU countries. So I will start here with the first issue, bidding organization and management. Here, one of the do's we think is starting very from the beginning, a systematic screening of all tender publications. So really to get to know of all opportunities. And there we thankfully have a very good platform, TED, where all contracts by contracting authorities throughout Europe are published. They have to be published there. So you get a full picture here, and you can even employ search engines or so to really find specifically these contracts which are relevant to you as a bidder. So this is very recommendable to set up a kind of search system to have every day the current contracts on the table. And of course, this is also well, a matter of transparency of the public procurement procedure. Now, if we go to the procurement procedure itself, we have here set out a short overview. It's the example of the standard procedure, the open procedure. And here you can have a first overview on the to-dos on both sides, you know, both the contracting authority and the bidder side. It's always a kind of ping-pong game. And you see here above the line the tasks of the contracting authority. So it's still quite more to do on this side. So it starts, of course, with the preparation of the whole public procurement procedure. And then it starts with the publication. And then the most important phase, of course, on the bidder side is going on the preparation of the offer. And here you also have the opportunity to use the Q&A function if the things are not clear. And this is also very recommendable. We will come back to this issue in more detail later on. And then after a minimum timeline of 30 calendar days, there will be the closing, so the submission of the offers. And afterwards, there is the evaluation of the offers, of course, again, on the contracting authority side. And then we have the system in Germany, but it's similar in other European countries, that you have, before the contract can be awarded, you have this preliminary information and then a standstill period from about, or at least 10 days, where you get to know who should win the award, and you can think about taking legal action before this happens. So this just is a small overview concerning the open procedure, and the same applies with a bit more complex procedures as the negotiated procedure. Here you have in the beginning an application phase where the applications have to be prepared by the bidder to show the eligibility. And then you have the closing just of this part. And then these requests are also evaluated, and the bidders which are most suitable are selected here by the contracting authority. And then this bidding phase afterwards is only done within this restricted circle of bidders. You have again the closing, and then, which is also a difference, negotiations would follow, maybe also in several rounds. And in the end, when the successful bidder has been selected, you also have this preliminary information, and afterwards the award of the contract. So you can see here also where the task for the bidder side is located. Now, going now into the organization management process. It's of course very important in our view to build an effective bidding team, to really define members of the organization who's responsible for it. On the one side for formal and practical handling of the bid, but then of course for the contents of the bid, which comprises different issues, technical, economical and legal issues, which have to be brought together. And so definitely we can say that successful bidding is a multi-professional task for a multi-professional team in the ideal situation at least. Then you also may consider that there are different forms to create your entity. Of course, you can do the tendering as a single bidder, but under European law, it's also allowed to build a consortium, at least in standard cases, and also to include subcontractors. According to the jurisprudence of the European Court of Justice, there is that the contracting authority is not allowed, to make any restrictions on that. There are only certain cases, for instance, if it's about so-called critical services, that the contracting authority can demand to do it as a single bidder. But in all other cases, this is possible. And the only thing the contracting authority can ask then is, of course, also to demand eligibility proof of the partners, of the consortium partners or the subcontractors, but the organization as such cannot be ruled in standard cases. So if you think about partnering, of course, it would be recommendable to an early approach of them, just to ascertain their availability, that they are not bound to another consortium, and also for a suitable and clear affiliation of tasks between the partners, the demarcation of these tasks, and because these partners also should often prove the eligibility criteria for themselves, as defined in the relevant tender documents. And of course, they have also to prepare their part of the offer. So there's a lot to do also for them, which makes it necessary to approach them early and really to include them into the discussion and the preparation of the bid. So these do's, of course, they are reflected in the don'ts, which is not so recommendable, is to start too late with the preparation of the offer, to disobey formal requirements, as this could lead to the exclusion of the offer, or to ignore unclear or unbearable work descriptions, because here, it is not so good if this issue is just then going on later. It should be made clear in the beginning, and if there are any problems, it's very recommendable to address them in the Q&A session, or to even file a complaint. So going on from this leads easily to the formal requirements for the bid. Of course, the deadlines have to be kept in mind, and all formal requirements have to be obeyed. Normally, we have now electronic bidding, so bidders should be prepared for this process, which is not that complicated, but of course, you have to look after these things. Then you should, for example, check if there is any signing requirements for qualified electronic signing, for instance. And of course, you need to make sure the completeness of bid documents. And here it's very helpful to make a checklist where we can then tick if you have everything time by time. It's also important to establish a bidding time schedule for the bidding timelines themselves, but then also for the internal or partner feedbacks and inputs you need, so that you have everything together at the right point of time. So this is a short overview on the formal requirements, and I'm happy to discuss now or later on. But then I would hand over to you, Volkert, with the topic optimizing the contents.
Thank you, Jacob. Much appreciated. Still a bit flattered that I was called Jacob. First topic from my side is on optimizing the contents and winning chances of your bid. And we found 3 key issues to quote unquote winning the game. And to start off with the work description or scope of the project. And second of all, the selection criteria. And third of all, the award criteria. And to start with the work description, I'm going to start with the don'ts, very big don'ts. Don't offer anything that the contracting authority explicitly didn't ask for. It's a bit needless to say, but it happens every now and then. Instead, use the words pages, so you like to offer what the contracting authority is asking for. And why shouldn't you offer anything that isn't required? First of all, it increases your chance of being excluded from the tender. And second of all, simply use the words on everything that is asked for. Second of all, regarding the selection criteria, one major do actually on this one, and that is to be very mindful on minimum standards and requirements. And the third point regarding the award criteria, 3 points on that one as well. First one is ask yourself, is this tender promising at all? If I win this contract, is it profitable in some sort of way for my company? Second of all, and a major hot topic, we just heard a lot about that a couple of minutes ago, is on ESG. What can I offer, what can my company offer to the contracting authority with regard to ESG? Even if it's not a specific demanded requirement, what can I offer that maybe my competitors in this market can offer to the contracting authority on ESG? And don't state like very standard things, but really try to fit in on what can the contracting authority ask for on ESG. And the third point on this one, again, is be as specific and matching to both the contracting authority and the contract as you can in your offer. Next topic is on communicating with the contracting authority. We just discussed a bit on the Q&A tool. We have a couple of do's and don'ts on this one as well. To start off with a do, start as early on as possible in the procedure with your questions in the Q&A tool for a couple of reasons, and mostly foremost because you want to be able to ask follow-up questions to the contracting authority. Very helpful to do that as soon as possible. And don't make it the contracting authority too easy on this one. Don't simply ask closed, simple questions, but really elaborate on what is your question about, what is the background, what do you want to see altered in the tender requirements, for example. Very important thing to do. Don't make it the contracting authority too easy. And then a next point is formal complaints are simple part of the game in public procurement. Ask your local CMS attorney as soon as possible in the procedure, of course, if you see some major infringements on public procurement law. And on that point, we have 2 specific tools you can use. For example, if you're an Austrian company doing a tender in, for example, so to say, the Netherlands, and you see something in the tender requirements that you don't really agree on, what do? You don't want to forfeit your rights. So what are your deadlines to start formal complaints? 2 documents you can use in that one. The first one is the EC documents, very helpful, very user-friendly. It's an overview of each and every European country, stating what your deadline is on starting with your formal complaints. and where to file your formal complaints. Is it at civil court? Is it an arbitration? Is it in a combination of both? Very helpful, but a bit of self-promotion over here. More helpful is the public procurement remedies toolbox created by some colleagues of mine and myself from Austria, from Switzerland, from Germany, from England, which gives you a very helpful overview on each and every European country with deadlines, requirements for filing your formal complaints in a tender. Would really advise you to take a look on that one, the Public Procurement Remedies Toolbox created by CMS. Last topic from my side before I give the microphone to my Swiss colleague Julia is regarding compliance rules. It's a bit needless to say maybe, but you should really avoid doing things as collusive bidding, infringement on local public procurement laws or specific tender requirements. And if your company nevertheless is accused of doing so, again, start as soon as possible with drafting up a self-cleaning measures plan to make sure that you're not excluded from the tender. This is all EU based. Now we're going to hear a bit on a non-EU country, Switzerland.
Thank you very much, Volker.
So, as already said, last but not least, I would like to have a look at some particularities from a non-EU jurisdiction, Switzerland. So I would like to start with some preliminary remarks. In Switzerland, we had a revision of public procurement law, and this actually brought a harmonization of the rules which were before really very diverse. So actually, this is really good news for bidders because it gets less complicated. But, and there is a big but, the new public procurement regime has not yet entered in force in all the cantons. So a big do, please just make sure that you check if really in your canton the new public procurement regime is already in force or not. And this is especially important with deadlines. So in general, you can say that Swiss particularities relate especially, but not only, to appeal proceedings and legal protection. I will gladly go into some of these particularities now. So as we have already heard, systematic screening of tender publication is one of the things to do. In Switzerland too, systematic screening of public and tender publication is of course essential. However, for us, the electronic platform of public procurement is not TAG, but CMS. On CMS, you can find an overview of all existing tenders across Switzerland. You can also sign up for free to receive regular updates on publications. And furthermore, on CMAP, you can also register as a bidder, so you can actually fill in your bids and also download the bidding documents, the tender documents. Tenders in Switzerland within the scope of international treaty, so especially within the scope of GPA and the bilateral treaty between Switzerland and the EU, is forwarded to TED. But all the tenders outside the scope of international treaties, especially the tenders, tender publications on cantonal level, are not published and not forwarded on TED. And also, this is also important, advanced notifications are also not forwarded to TED. So it is important, if you are interested in tenders in Switzerland, to check CMS. So another question that often arises and we are often confronted with is a general question. If a foreign company is allowed to participate in a tender in Switzerland? And here the answer is, how so often with lawyers, it depends. If it is a tender within the scope of an international treaty, or also if the country of origin grants reciprocity, you have the right to participate in the tender. But for tenders without, outside of the scope of international treaties, it actually depends on the contracting authority. The contracting authority can decide to allow foreign bidders to participate or not. But what is important, if the contracting authority once has made a decision on this, she is actually bound by this decision. So finally, foreign bidders which are allowed to participate, they have at the end the same rights as Swiss bidders. And in such cross-border constellations, one of a factual difficulty is also country-specific permits or certificates. This can pose a challenge both for foreign bidders who want to participate in a bid in Switzerland, and also for Swiss bidders in foreign, respectively EU tenders. Here it's always the question arises which equivalent proof of the bidders are accepted. So we've heard already lots of do's and don'ts. Also for Switzerland, it is always important to carefully review the call for tender and the tender documents. And in Switzerland, and this is a big difference, unlike in the EU, it is possible actually to prohibit consortia or the involvement of subcontractors. However, such a prohibition must be mentioned in the tender documents. So before joining forces for a joint bid, always carefully check in the tender documents if you are even allowed to do so. I think this is quite different at EU level. Another thing to keep in mind is that for services provided in Switzerland, foreign bidders also have to observe Swiss-specific regulation, to think of especially on the working conditions in Switzerland, and also environmental aspects. So foreign bidders should actually make sure that they are familiar to these regulations, and also that they are in a position to actually observe them. Another important point are the time limits. Here, you have to keep in mind that the time limits for submitting the offer are partially different in Switzerland. And what is also different, as we already have heard, at EU level, you have electronic bidding, which is the standard. In Switzerland, we need some more time. So at the moment, the standard is still non-electronic bidding. And here it is important to note that the offers must arrive at the procuring entity within the deadline. So just don't wait to hand to the post the documents on the day the deadline ends, but really make sure that the documents are at the contracting authority at that day and at the time also is set. As you've already heard, luckily with the new public procurement regime in Switzerland, the period to appeal of a decision of the procuring entity is now overall 20 days. Before, you always had to check in which canton you are, and the deadlines were very different. However, as already mentioned, now these new rules are not in force in all the cantons, so which is why the old 10 days deadline are still in force in certain cantons. So always carefully check which time limit actually applies. Another point that often gets forgotten is that in Switzerland, shortcomings in the invitation to tender must be challenged immediately within 20 days after the publication of the tender. So for bidders, if bidders find shortcomings in the tender documents, they must challenge them immediately. After, shortcomings cannot be invoked anymore when appealing against the award decision. So finally, we come to the stage of the conclusion of the contract. The conclusion of the contract is actually a milestone in Swiss public procurement procedures. Once concluded, a contract can in principle not be annulled anymore. In this context, it is important to know that in Switzerland, appeals do not have automatic suspensive effect. This means that the contracting authority may conclude a contract even in the event of an appeal, unless the court expressly grants suspensive effect to the appeal. And suspensive effect is thereby only granted upon request by the appellant and following a summary assessment by the court. So this is something for both sides always to keep in mind. If the suspensive effect is not requested by the appellant in his complaint, or also requested, not granted by the court, the contracting authority is free to finally conclude the contract. And once the contract has been concluded, the contract remains on force, even if the court later approves the appeal against the award decision. Therefore, in practice, appeals are usually withdrawn if no suspensive effect is granted and the contract already concluded. You hear me? Hello? Yeah,
That's
just
good.
now.
Okay.
Thank you. So one can say the summary decision on the request of suspensive effect is in Switzerland as important as the final decision. And yes, of course, even if the contract is concluded, there is still the possibility to claim damages. However, in Switzerland, to claim damages is very difficult and it's also extremely limited. You can only claim the necessary expenses for preparing and submitting the bid. From a procedural point of view, it is important to note that the appeal court also decides on claim for damages, and this on the same time when deciding on the violation of the public procurement law. So therefore, it is always important to include an alternative motion in the appeal for damages. So with this, I would like to close and I hand over to Mark.
Thank you very much, everyone. I have a couple of questions that came in, but would first give the opportunity to everyone here. Any kind of questions to our three speakers or myself that you would have on do's and don'ts in submitting bids? I'll give you a bit more time to think of questions, or then yeah, Virginie, you first, and then I'll come with the ones from that came in online.
Just wanted to know within the crowd and you guys, if you also have often the case of companies submitting references from another company of their group, you know, like I just say an example. The buyer Germany uses a reference of buyer Belgium or things like that, but they do not submit ESPD from this other company nor a commitment of this company to put its means at the disposal of the tenderer. or the contractor, and that therefore the reference is disqualified. We have that a lot in Belgium, this particular situation where a company, well, these huge groups, for them, you know, they all part of the same company brand, whereas actually they all have a legal different personality. And that's why actually a reference of one Belgian company is not okay if it's the German entity that submits a bid, unless there is a commitment of this company to put its means at the disposal of the contractor. Yeah, for us it really happens often. I would put an enormous do or don't on that, because I mean we had to consider irregular tender because of that still today for a huge contract, and it happens all the time. But maybe it's a Belgian specificity, or just wanted to know if it happens in other jurisdictions as well.
Okay, Jacob, any comments on that? Yes, I can confirm that it's also a very contentious issue in German law, under German law. And I think, well, the bidder has to prove the availability of this other unit if he wants to use these references. Yeah, that's just the case. But it's also not that complicated, you know. You just have to make a declaration that this part of the company is included in the consortium or as a subcontractor or whatever. So that should work then. And the other thing, sometimes, you know, it's sufficient, but there is no legal certainty about it if you don't do it like this. So it's of course recommendable to look after that also in the early stage, I think. No, Christian?
Yeah, another German comment. I would say in my practice, I don't see any issues around that like you do. Because often, I don't know whether this is the same in Germany, in Belgium. In our procedures, they have always certain the specific forms, and it's written in the invitation to tender to do that. And then the recommendation, which was given earlier, they have to read the tender documentation. I think that's, I don't know whether this is the case, the same in Belgium, that they have all these forms, but in Germany, at least in my practice, I don't see a lot of companies having a problem with that.
It's part of the tender documents in Belgium as well, and we write that in big letters and etc. But still,
they can't read.
But personally, it's in the European single procurement document, right? It's just
as well, yeah, indeed.
You must be blind not to read it.
I totally agree. Totally agree, but still it happens. It's like, you know, CMS Belgium using a reference of CMS UK without putting all these forms together, because we are all one same firm. But yeah, but indeed, it's written that you have to fill these forms and an ESPD, etc. But yeah, I don't know why, but in Belgium it happens all the time. Yeah, maybe.
Maybe one comment. I see many hands right, which is great. Just one comment. I mean, yeah, you would probably feel tempted, especially when you're in a group of companies, to kind of rely on references from, you know, sister companies or mother companies. And I think the issue there is just you need to prove that they're actually involved in whatever kind of work or service they have to provide afterwards. In other words, at least for us in Switzerland, that wouldn't work. Because what you want to see as a procuring entity is that you actually get the reference in for those that actually do the work.
Exactly. Yeah.
I have a question or a comment that is a bit linked to what to the comment that Virginie has made. What in our experience, what we see is with tenders that bidders that uses group companies, especially in supply contracts from other countries outside Austria, where they have a lot of problems to get the documents that prove there are no exclusion grounds, and especially, for instance, it's always a challenge for a German company, obviously, to get an excerpt from a criminal register within the tight time limits that many contracting authorities give to the bidders. Do you have a similar experience in your jurisdictions?
Anyone comment on that one? Seems to be a single problem in Austria.
It actually, sorry, is a problem in Poland. I can just give you an example. Because I used to work for a supply company that was submitting public procurement bids in Poland, and half of the companies had mother companies in the US. So getting the documents that, like, for example, in Germany, are those criminal records. In the US, they do not have something like this. They have a police certificate. And that was actually the problem, that my company has been excluded at least 5 times from those procedures, and we have filed complaints, and several we actually won. So I think it's probably an issue with those mother companies being abroad and not complying with the documents in the countries. Yeah.
Graham, yes.
Yeah, just so there's a problem with the UK. I'm not sure how it works now. It should work the same, I guess, even being outside of the EU, but we don't have a criminal register for companies. It doesn't exist. So the e-cert is sort of the equivalent is just some notarized document. It's very unclear what it is, but we've had problems in Poland with clients of ours bidding for contracts in Poland that then get excluded because the authority in Poland is not prepared to accept a sort of notarized document from the company itself or from its lawyers.
Yeah, we just had a similar case for Austria, actually, where apparently in Austria you need a kind of Gewerbebewilligung or something like that, which actually is permission to do your business, which in Switzerland you would just be allowed to do, except you're in some certain special security area or something like that. And it was quite a challenge to actually advise, and we did that together with our colleagues in CMS Austria then, on what would you have to, kind of chip in as a Swiss company for something there is simply no certificate or permit or whatever. Virginie.
Yeah, no, I agree. We have these issues regularly with company based in the US or in the UK bidding in Belgium, where you also need this this document, criminal report for the company. We have done some research on that, and the only thing that would be satisfying would then be a declaration on oath before a notary. And the self-declaration would not be sufficient. And there is a decision of the Court of Justice on that, I think. Well, I know. There was a debate on, can we not do a self-declaration? And unfortunately, because of this decision, no, it's a real declaration on oath before a notary or bailiff or an official officer. And that takes a bit of time to organize. So yeah, as a bidder, you have to organize that well in advance when you have to involve a company where these documents are not easily available.
And you'd sometimes be surprised that they don't address the topic. I mean, it is known now to some extent that certain permits are country specific, so at least you should provide some guidance, I would say, as a procuring entity for everybody who's coming from somewhere else, what you should do there. So yeah, but it's a bit of a headache, I would admit. Yeah. I have another question here, which relates a bit to, I think, you, who was it? Who had mentioned something on collusive bidding? Was it you? Yeah. Jakob, was it you? Okay, or both of you actually. One of the two Jacobs, the younger one or the other one. Both are talented. So the question here would be, how about multi-bidding came in here to enhance the chances? Is it possible, for example, to take part as a bidder and at the same time as a subcontractor for another bidder? Or, and I guess that's behind the question, would you run risk of being kind of, being alleged of colluding because obviously you're involved in two offers?
Well, this raises very interesting questions about multi-bidding. Yeah, and how far can you take part in a public procurement procedure, for example, as bidder and simultaneously as a subcontractor? And for example, this constellation, at least under German law, but I guess also under the complete European law, is in principle admissible, because of course the offers have to be kept confidential among the bidders, but here the subcontractor only is covering a part of the bid of the other one, and so it's considered as admissible. So you would have a good chance to enhance your chances. But of course there are other constellations which are more dangerous, more complicated. For instance, to take part as a bidder and also as a consortium, which is not to be considered allowed under German law, or at least it was always the case. But actually the European Court of Justice has relegated that in one decision also a little bit, but this is at least a more dangerous constellation. But the other one would be okay.
Yeah, I guess same situation when you're in two consortia, just simply because of the exchange of information you would have, at least from a competition lawyer's perspective, I would say so. And I would say, yes, subcontractor in one and bidding consortia in another, that probably would make it necessary that you don't get access as a subcontractor from the other consortia or from the other bid to the actual bid, but just to your part, I would say. Otherwise, it's probably really exposed, I would assume. Yeah. I have one more here, and that I'm just reading that out. Well, the practical one here. Is there anything you can do if for any reason you're running late with preparing the offer? For instance, because the publication has been discovered too late. So would you see any possibility to kind of control that damage or avoid it? Tricky one.
Read carefully.
Yeah, we know that so far.
So I will simply answer what we do as contracting authority. First of all, the bidder should contact us and ask us for an extension of the deadline. And then we have the discretion to decide, and it's a case-by-case basis. If we have very little competition and we want more offers in, we are likely to say, yes, we will extend. If we have large competition and we are under time pressure, we will say, sorry, no. So that's the answer.
And that wouldn't expose you to a risk of appeal by other bidders who would say, I respected the deadline, and why would you now another one allowed to come in late, although he missed it?
So, so hold on. So the extension would be published before the deadline actually ends. That's clear. We cannot extend once the deadline has passed. So, and before it has ended, and as I said, if we have valid grounds because we want to increase competition, I don't think this would be subject to a valid challenge.
Yuri?
Yes.
Thank you. No, I fully agree, but we have one older case before the Belgian Council of State where the contracting authority extended the term just a couple of hours before the deadline, where it was considered to be illegal. So be cautious at some point.
No, I agree. We're talking about several days minimum.
Volker, I have another one for you. Oh, excuse me. Please go first.
Yes, hello. Just to add something from our practice, I would say that in the local laws, usually there are deadlines in which the participants, bidders, interested third parties can ask prolongation of the term, no matter of the reason. Sometimes there should be a reason, sometimes not, but there are always deadlines in which you can ask the contracting authority to prolong the term, and it's of course up to its decision how to proceed. And it depends on the procedure, of course. In some procedures, it is not possible. In some procedures, it's discretionary.
Virginie?
I think that probably depends from country to country, because I think in some countries probably you have deadlines, but in others you don't. But I agree. In general, if it's just a few hours before and it's clearly done just to favor or save one company, it could be seen as illegal or discriminating. But if it's done before and with valid reasons that maybe should be noted in the file by the contracting authority, then I don't see the risk. I mean, the risk of a remedy on that is very low, I think. Yeah, it depends from country to country, indeed. But you don't have always deadlines. We don't have deadlines to ask that, for example. But in some countries you probably have, indeed.
Another interesting one that I wouldn't want to let go is what should we do if we are not satisfied with the award decision, but we are not sure whether there are good grounds to challenge it? What possibilities do you have right now? Well, my short answer would be, ask the contracting authority for a debriefing, at least. Sometimes they're hesitant and they try to wait very close to the appeal and deadline. We've seen that at least. In Switzerland, I know, asked for a recent decision, but maybe there's other hints and tricks that you would see, but that's probably what would come to my mind.
I would say contact your local CMS lawyer to find.
Okay, since you are here, I'm obviously Volker, our marketing guy here. I have really last one for you. That's a very, very classic one, and it helps us boost our practice. Which would be how many countries actually did contribute to the remedies toolbox? Do you know that?
I think we're on 14 or 15 at the moment, and counting. So quite a lot already. So yeah. Complete overview.
Good. So that would be, at least I don't have any other questions anymore. Is there one more? Oh, great. Thanks. Still have 5 minutes. Perfect.
Thank you. So speaking about do's and don'ts, I would like to add the importance of a tender preparation phase and compliance with competition law, because you can get in most troubles in terms of competition law in the tender preparation space. Speaking of, for instance, agreeing with the contracting authority in advance preferable terms, which is not right, of course. So in Hungary, we have to threaten, unfortunately, our clients, the bidders, that they should be really careful, because the only case when they can be personally liable and it qualifies a crime is bid rigging in public procurement. So I wonder if is it the same in other countries, that it qualifies as a crime in public procurement collusion, competition law?
Kicking off in Switzerland, no criminal sanction, but you could be caught up in fraud, probably in some kind of constellation. But there's no specific criminal sanction for that, for bid rigging or any kind of collusion in relation to public procurement. But I know there is in other countries.
Probably no.
I know there is.
Hello, I'm coming from a more exotic jurisdiction. I'm from Colombia. And yes, in Colombia, it can be a criminal offense. It can be a criminal offense if you're reading a public permit, so if you're not fulfilling some of the requirements, and in any case, you're signing the contract and proceeding with executing the contract. It can also be a criminal offense.
In Ireland, we are getting a new Competition Management Act, which is coming into force on the 22nd of this month, and bid rigging is particularly singled out as a new criminal cartel offence. So it's in there. And just to come back on the previous question, to get out, if you're unsure whether a tender award has been unlawful, in Ireland certainly we have most public authorities are subject to freedom of information legislation. So we would very often make a freedom of information request on behalf on behalf of clients, and it's amazing sometimes what you get back, because the Freedom of Information Officer is often more willing to give more information than the procurement department. So sometimes you can get lucky.
And would she or he be quick enough to get the information in time in order to respect the deadlines?
Well, often or sometimes the response to the Freedom of Information request can trigger a new limitation period of 30 days. So the contract might have been entered into already, so you know the suspension has gone, but at least you could still have damages. But yeah, it's less appealing.
Okay, interesting. Graham?
Thanks. Yeah, so just like in Ireland, there is a cartel offence that would cover principally a criminal offence as well as a civil competition act offence. And I know we're coming to the end of this session, but one thing just sprung to mind, which we have had quite a lot recently, is it's a slightly different situation, but where you're the winning bidder and you, for whatever reason, you decide you don't want to sign the contract anymore, and whether in other countries, because it's not really dealt with in the our procurement regulations. The principle's really contractual, so until you've signed a contract, you can withdraw. But I was wondering, it might be quite different in other countries.
Yeah.
Sorry, I didn't mind. Another one.
Interesting. No, I would say by placing your offer, you're bound to your offer, and that's kind of it's a matter of acceptance by the contracting authority, and then you have the contract.
You're explaining Dutch law now.
Because it's the same.
So but in many cases you see the height of the other offers and you think, oh, I was far too low, and then you say, I want to withdraw, but it's not possible.
Good. If my colleagues on the panel agree, I would say we close this session, and I would say now, I don't know, over to the hosts, what your plans are with the rest of the afternoon with us. Thanks.
Yeah, thank you. You are now, of course, welcome in the coffee break. And yeah, we will continue already at 15:15. So just 15 minutes. Thank you.
I need a mic.
So if you would like to take your seat, then we could continue. Well, as scheduled, we are now happy to that some recent highlights from the ECJ are presented and practical takeaways for bidders here. And Christian Scherer, my fellow and partner, Lenka Kutakova, and Yves Steingruber will present that. So the floor is yours.
Yeah, thank you. So the next highlight is coming now. The highlights of European case law. And you already introduced the panel, so I can skip that. I think Lenka, Yves, and we will present some recent court decisions, European court decisions. Perhaps somebody can close as well. And yeah, what we did already last year, we put the cases in order to follow the normal procedure. So you can follow the procurement procedure, and then we would discuss issues around that and recent decisions. We start with the preparation of the procedure, and then as a procurement authority, you have to see how to structure the procedure. We will have some issues and cases on these issues. Then the next step is in the most procedures that you have to select the tenderers. You have to see, you have to check capabilities and exclusion grounds. This will the next step, where we have in fact two decisions to discuss. And in the next step, if the tenders have been submitted, the authority has to select the decision, or not, make a decision on the award of the contract, which tender will win this procedure, this procurement. And this is where we have another case we would like to discuss with you. And yeah, first step is structure of the procedure, and Yves, he will give some cases on this, and the floor is yours.
So thanks, Christian, for the introduction. And as Christian mentioned, we started with the structure of the procedure. Yeah, structure of the procedure. Well, I know, and frankly, presenter could be helpful. So frankly, I know structure of the procedure, it doesn't sound so smart. It doesn't sound so sexy like exclusion grounds or award decision. But we all know the structure of the procedure. It's the first step in every single procurement procedure, so it's quite relevant. If we make a mistake on the step that we learned the lesson before, then it infects all the other stages from the procedure. So I just want to draw your attention to this first stage of the procedure, and to highlight some judgments of the ECJ that are also quite relevant for the bidders. So just for your overview, where we are, what we're talking about in the next minutes, we're on the preparation stage. It's the first stage, and we have different items that have to be to keep in mind. And we start with the identification of the procurement needs. And the background of the overview is to show you where we have to sort in the cases that we're talking about the next minutes. So we start with the identification, the definition of the needs. What do we need from the view of a contracting authority, especially what kind of a public contract? It's a concession, a public contract, or a framework agreement. We will talk about framework agreements. Next step is application of EU public procurement law. We all know the contract value and the thresholds are quite important. We will focus a little bit on this point also. And last but not least, which is quite relevant, is the choice of the procedure from a bidder's perspective and also from the perspective of the contracting authority. So it's a decision whether we will choose an open or a restricted procedure or a competitive procedure with negotiation. So that will be another key issue we will focus on. So, and last but not least, we have the preparation of the documents. To this point, there will be no case. So that's for your short overview. So we start, and we have a decision from Austria from last year with the interesting name EPIC. Whether it's an EPIC judgment, that will be your decision at the end. But we start with the case EPIC. EPIC, just the facts. The Republic of Austria concluded 21 framework agreements with one company each for the supply of COVID tests. So it's a case about COVID tests, and it's a case quite relevant for framework agreements. So I tailored these slides in regard to framework agreements. Also quite interesting in decision and quite important was questions regarding the review procedure, but it's more from Austrian perspective. So we will focus on framework agreements. What happened next? We had no publication of the contract notice, and we had no notice of award of the contract. And the framework agreement provided for a maximum purchase value of 3 million euro. So guess what happening next? In two cases, the framework agreement, the individual call-offs, exceeded the maximum purchase value. So what comes next? What was the judgment of the ECJ? Yeah, we had 2 points, 2 issues that I want to point out. The first issue is the standstill period in relation to framework agreements, and the second issue is the limitation in regard to framework agreements. So let's start with the first issue, the standstill period. The ECJ points out that the directive regarding the review procedure is also applicable to framework agreements. It's just a clarification. So you have to observe the standstill period of 10 or 15 calendar days in your procurement procedure. The second issue, also quite relevant for bidders, is the limitation in the framework agreement. The court points out commitments only up to a maximum quantity or value are possible. If you exceed the limitation, that's from the decision, the framework agreement will no longer have any effect. That's a consequence. However, there's a back door, you could say. If you reach the limit or exceed the limit, you have to observe that unless the award does not entail a substantial modification of the framework agreement, it's still possible. So if you have the limit exceeded with €1, from my point of view, it's not a problem. But you have to observe the regulations regarding a modification of the contract. That are the two key issues from this judgment. But what are the implications for the practice? At first, you can sum up the judgment takes up and continues the previous case law. We heard last year in Oslo the case Simpson and Wheel. All these requirements of the ECJ are just take up and continued by the ECJ. But now, what are the key points for a bidder and framework agreements? At first, the specification of estimate quantity and estimate value, as well as the maximum quantity and the maximum value, have to be made. They have to be made in a tender notice, or they have to be made in the tender specifications. Another point which is important, the standstill period is applicable. And last but not least, if the limit has been reached, the framework agreement will no longer have any effect. Unfortunately, it's a pity that the ECJ doesn't or didn't use the opportunity to clarify what this means have no longer any effect. Does it mean automatically, or does it mean we need an act of a bidder to contest the framework agreement? So that will be a point perhaps for the next decision of the ECJ regarding framework agreements. Coming to the next case. It's the case also from last year, and it's, hopefully I pronounce it in the right way, it's Rasulok. What are the facts? The facts, quite simple. We're tendering an open procedure of several lots by a small Bulgarian town. The estimated contract value of the relevant lot was 17,400 euros. So I look into your faces, some look a little bit confused. Why we are talking about such a case, 17,400 euros. It's more or less peanuts in public procurement, but it was a decision of the ECJ. So first point, applicability of the EU directives. So what happened next? Only one bid was submitted for the lot, and the bid price was twice the estimated price. So guess what's coming next? The contracting authority discontinued the procedure. So subsequently, the contract was awarded in a negotiated procedure without prior publication. And to whom? Of course, to the bidder of the open procedure, who was the sole participant in the procedure. So what was the reason for choosing that kind of procedure? It was just a lack of suitability from point of view of the contracting authority. Just give a short view on the judgment. Now we have also two general issues. The first one, as I mentioned, and which is obviously EU law below the threshold. Am I right? And the second one is, of course, the negotiated procedure. Just come to the first one. Why we are talking about EU law below the threshold? It was a preliminary ruling, and the question which was raised by the Bulgarian court was just regarding the European Structural and Investment Fund. So it was the problem that the contracting authority uses resources which were financed by the fund. That was the link or the part to open the door to the ECJ. The ECJ said that we don't know how to apply with the rules for the fund, so they do not apply, but we have to look at the Bulgarian law. The Bulgarian law faithfully transposed the directive for the procurement procedures below the threshold. And the ECJ said that allows us to interpret the law, and that allows us to give us some guidance to the Bulgarian court how they have to interpret these provisions. So the aim of such, the idea behind the ruling was that we need a uniform interpretation of EU public procurement law. So that's why public procurement law from the EU is also relevant below the threshold. The second point, the negotiated procedure. The ECJ points out that a tender must be considered not to be suitable in the sense of the EU directive if it's unacceptable. So quite interesting wording. And what does mean unacceptable? In this case, it was quite clear. Unacceptable is a tender that's higher than the expected value of the contract. So here it was twice, and the ECJ could say, yeah, twice the amount, it's too high, it's unacceptable. You have the possibility to change the procedure and to use a negotiated procedure without prior publication. So what are the takeaways for the practice? At first, as I mentioned, the directive could also be relevant below the threshold. I don't know if in other jurisdictions we have the same cases like in Bulgaria. In Germany, we have it. Below the threshold, we have rules that are transposing faithfully the EU directives. And another point is the key points regarding the negotiated procedure. It means that high prices could lead to an unsuitable tender. And if an award procedure is discontinued, direct negotiations can still be held with individual bidders, especially about the price. We have seen in this case, we had the first offer was twice the expected value with 17,400. At the end, we had a price from 17,365 euros. So it was quite successful to negotiate with the bidder. And you don't need special characteristics of the contract to choose this way. And last but not least, another aspect mentioned by the ECJ, which also convinces myself and is relevant for bidders, you have to take in mind the prior open procedure and the subsequent negotiated procedure, they could form an indivisible whole. That would mean if you're a bidder who do not participate in the open procedure, you don't have the possibility to contest at the end the negotiated procedure because you had the opportunity to be part of this procedure. You didn't use it, so it's your own program. Yeah, and that's the implications for the practice for the second case, and I will give the mic to Christian and the exclusion grounds.
I have it already, thank you. I forgot to mention, if you have any questions or comments, we would like to, we would ask you to give them now, not in the end of the presentations, because it's easier because now you have all the talk in mind and the information. So do you have any questions on Yves' cases? Yes, Juri.
Regarding the first judgment, the standstill was only for the award of the framework contract itself and not for the mini competitions?
Yes, this was only for the framework agreement. There was no hint of if it's for the mini competitions, unfortunately. Yeah, because in Germany it's a question whether we need such a standstill period for the second stage, but it was not made clear by the ECJ, unfortunately.
Back to the EPIC judgment, maybe I can give you some more background information on that, which is, I think, quite funny, but also a bit sad. The question was raised by one court that is competent for review procedures in Austria on the federal level, and at that court, approximately there are 5 judges doing review procedures, and one judge, and that was the judge that raised this question, is regarded in the public procurement community as, to say least, problematic. So whenever you get assigned a case with that judge, then you can better also go to a lottery. You will never know what comes out. And that case was actually, you made it very well because you only showed us now the most important questions, but the judge raised several other questions were completely nonsense. And I mean, and I was actually a bit surprised that the European Court of Justice really answered all these questions about the charges for the review procedure, if they were equivalent and blah, 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 blah. And actually, also these questions that the judge raised, to me, it was quite obvious what the ECJ would answer, and actually that's also the case. I mean, the only, I think, important or the new information that we received from the ECJ in that case was about the maximum value of a framework agreement, that you have to state that, and you have, but I think it's quite obvious as a consequence, if you exceed the maximum value of a framework agreement, you simply cannot assign contracts under the framework agreement. To me, this is actually, yeah, obvious. What I mean, there's no alternative under that. So in Austria, we a bit laugh about this decision.
So I think EPIC is a good title of the decision. If you read it, yeah. Yeah, but you're totally right regarding the limit. It's also, if you have to look at in view of the modification of a contract of these provisions in the directive, also in Austrian law and German law, I think it's quite clear, but it's a clarification of the ECJ from my point of view. Yeah.
But couldn't you also say that it becomes more complicated to include a maximum, because framework agreements are already bound in terms of time, 4 years, and for procurement entities it's quite difficult to name a maximum upfront. You don't know the maximum.
But it's quite important for the bidders to know if there's a maximum, to know what resources do we need.
But for bidders,
yes.
Sorry, is it an estimate, or was it an estimate or a maximum?
Yes, but if it's an estimate, that's okay. But now it's a maximum.
It's a maximum, yeah.
So that's I think for bidders also, they are not they're not very enthusiastic about the maximum, because if you enter into the contract, you don't care about a maximum, and your competitors who didn't get the contract, they are sure that they will get a new opportunity in 4 years' time. So I think it makes procuring a little bit too complicated to have this obligation to mention the maximum.
Yeah, you're right. And sometimes some parties make the instrument of a framework agreement ridiculous. The flexibility is lost. Yeah,
Precisely.
yeah, it's of course, yeah.
Yeah, and some contracting authorities also fear that if they put a maximum, it will incentivize the bidders to higher their prices, because the maximum is just the maximum. It's not what they intend to spend. It's what they, well, it's the maximum. So there is obviously a margin for, improvisation, etc. And our clients always say, well, I don't want to put my maximum because it will incentivize bidders to put higher prices, and I don't want that. So then we write, this is a maximum, we take a margin, it's not our target price, blah, 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 just to show to the bidders, this is not the target, please. But yes, it's a difficult one.
So now I regret that I mentioned that. Okay, next topic, as pronounced, very sexy, is exclusion grounds. My introduction is here because we are looking here in the stage where we have to see which tenders are allowed to tender or are accepted, whose tenders are accepted. Because in the procurement law directive, Article 56 says, a tenderer may only be those who are not excluded and who meet the selection criteria. And as you've seen from the title of this presentation, we are focusing on the exclusion grounds. And if you are a professional in procurement law, we have mandatory and discretionary exclusion grounds. And then you must see, and we will further look into this, whether there are other exclusion grounds. And then we focused on that in our last procurement forum. If you have an exclusion ground, you may nevertheless be accepted if you have carried out valid self-cleaning. We will not focus on that in one of the cases here, but the last point which has to be seen is there's also a maximum period of exclusion. Even if there is an exclusion ground applicable, after a certain period of time, you may not be excluded anymore for this event. So in my practice, and also for our case law here, the mandatory exclusion grounds are not so relevant, except for example, the one not paying taxes or having tax issues. But the discretionary exclusion grounds, they are much more relevant, at least in my practice. And there are, I would like to focus here on two exclusion grounds, which at least in my practice and in our practices are more relevant. The first is non-compliance with certain social and environmental laws in public procurement contracts or public procurements. And the second, the second one is grave professional misconduct, which is certainly the one with the most scope, or the largest scope in our practice. Then the next one, which is also very relevant in practice, is if one of the bidders has entered into agreements distorting competition. Anti-competitive behavior can be an exclusion ground. And fourth ground I would like to mention here is if in a formal contract, in a form of public contract, the bidder is guilty for deficiencies, which in fact led to a termination of this contract, or other consequences. I mentioned already the maximum period of exclusion. As we will have a case on that, I would like to give some insight here also on that, where we had two provisions. In fact, there we have also, we differ between the mandatory exclusion grounds and the discretionary exclusion grounds. For the first, is 5 years is the maximum period, calculated from the date of the conviction. It's quite clear provision. And the next is 3 years from the date of the relevant event. That will be an issue we will be looking into in one of our cases. And then start with the first case, which in fact is a German case. And please have in mind that we have here two companies involved, J and K. K is a company, and J is also is in fact a natural person and also doing business. What is the case? What are the facts? In fact, it's an open procedure, a public contract for public transport services, bus services. So, and J, one of these public companies involved, is a trader operating under his own name. So he's in his person is doing business. And K Reisen means travelings, is a bus transport company of which J is managing director and sole shareholder. So, and then we have this bid, and both are submitting bids, independent bids, at least 2 bids, separate bids, not independent. So we have a bid of J and a bid of K. So we are talking about exclusion grounds. What happened? Well, they were both excluded for breach of competition rules. So, but we had this already discussed before, but I think that's even worse here. You have more or less the same person involved in both bids. So the authority argues the tenderers are in a position to concert their respective tenders. That's why this is a breach of competition rules. That's why exclusion. J and K, they argue. We are 2 tenders and we do not fall under Article 101, which is the provision on anti-competitive behavior or agreements in the treaty for the European Treaty. And because, that's even worse, because we are in a economic unit. So that's why this provision 101 is not applicable. So the competition lawyers of us, they might know about this more than I do. And we have this list of exclusion grounds, and it doesn't say that in these cases you may be excluded. So why do you can't exclude me? This is an exhaustive list. That was her argument, and in fact, in the first instance, this went through in Germany, but then the Court of Appeals, or the one who was deciding on the Court of Appeals, submitted questions to the ECJ, and then he decided as follows. First on the exclusion ground, whether or not whether this also includes, there's this one exclusion ground saying that you can exclude in the case that there is an anti-competitive behavior or agreement. And the court in this ruling emphasized that this is not the same, has not the same conditions, this exclusion ground, as Article 101, because it does not has as a condition that it must be an agreement between undertakings, and the difference is the exclusion ground does not require that there's an effect on trade in EU. And this, as it was the question which was raised, whether this this is an exclusion ground. What is the relation between the exclusion ground and 101 TFEU? He said that this is the question, this is the difference between these two rules. And in fact, this exclusion ground must be interpreted broadly. And it's not limited to such contracts or agreements falling under 101 TFEU. This was the first question, which the first answer. And he did not decide on the case as such, and only on the question raised. The second issue, which was here, the question is whether or not, as was argued by the applicants, the list of exclusion grounds is exhaustive. And the court says, yes, it's exhaustive. But that does not mean that a member state may adopt rules to ensure equal treatment in a procedure. And if there are no independent and autonomous bids, then there is an infringement of the principle of equal treatment, and you can, as a member state, take consequences for that. And say, in such cases, the principle of equal treatment is infringed, and therefore you can nevertheless exclude this bid. But it's not an exclusion ground as such, but it's an infringement of this principle of equal treatment. So, a priori, it says it's the case even if such a non-independent tender is to be seen if there is an indication of influence from one bidder to the other. And even worse is if there's an economic unit, as in this case. That was the ruling, and the question was, what did the German court with this? Because they had to apply these general statements. We have a broad interpretation of the exclusion grounds regarding agreements aimed at distorting competition. But in fact, the German court did not rely on that. The German court applying this decision says and relies on the principle of equal treatment and decides, in fact, that the exclusion of the tender for infringement of this principle was okay. In practice, we see that authorities must, in fact, assess whether these bids, if they have indications, if there are links between these companies, have to assess whether or not these tenders were prepared autonomously and independently. I mean, that's something we discussed already a bit earlier. But in this case, as there is the individual person is the same in one and the other bidder, it's not possible that they don't know of each other, and it's not possible to be independent. That the list of exclusion grounds is not exhaustive is also relevant. At least in Germany, we find more and more exclusion grounds in specific laws. We have already mentioned this law or this act on supply chain compliance. This includes also a provision saying that in certain cases you can that has effect on the procurements. If this is part, or if there is an issue in the public procurements, and this is just to say that these laws may only be, may justify an exclusion if they also meet the criteria of the European exclusion grounds that you have in different, especially the social laws, and especially that's also an issue which is, I think, in Germany not discussed so much, but that's an issue which I think follows from this decision. This is on that case. Now I wanted to go
come to another case with in fact. Yeah, okay, Peter. Yes. Want the mic?
So I think the difference between exclusion grounds and exclusion measures was already stated before, right, by the European Court of Justice in several cases, like the Assatur case, that was the same. But what's not clear for me here in this case is why was it profitable for these two companies to submit two bids? Because we have many questions of clients in the Netherlands also. They want to participate in two bids. But how would that have helped them? You see in certain cases, you see where the outcome of the award criteria is relative, that you can sort of play with the outcome. So you hand in one bid with an extremely low price, for instance, and then the other one with quite a normal price range, they score higher under the award criteria. Then that's a quite clear example of infringement of competition law. But if that's not the case and you've got two separate bids from a natural person, you said, right, J, and then company K, okay, they both hand in a bid. I'm sure the natural person will be aware of you cannot not know the content of the other bid, so he knows. Is that immediately an infringement of competition law? I don't think so. I'm almost finished, but we had a rule in the Netherlands saying that it's forbidden to submit a bid twice, and it's now case law that such a rule is not admissible. We cannot forbid entities to submit a bid twice. There has to be something more. So in this case, my question, why did it help them?
Why they did it, I don't know. I mean the bidders. I don't know. I didn't say.
It's not an immediate infringement of competition law, I would say.
Yeah. In Germany, we also focused, at least in the discussions, that there is no secret between, because in fact that's the question of independence, and then and that's the question, and that's what we don't want, that the people or the bidders know from other bidders, and there's this this danger of influence. But the question is, it might be the better bid, in fact, I don't know, but yeah, I have no answer for that, more than that. Or Yuri?
No,
but I was already.
I will
yeah,
be very
please,
quick.
yeah.
In Belgium, we still have the rule that you can only submit one bid. And regarding the competition point of view, I'm not a competition lawyer, obviously, but my reasoning would be that it would be a violation of the equal treatment if you give all the tenderers like one chance to win the contract, and the rule is clear, you only have one chance. So why would a specific tenderer has two chances? Or if you don't have the rule, you can argue, yeah, then everyone can submit 2 or 3 bids, but it's
submit 5 bids if you want to, but how does it help? But it has to make sense to submit 5 bids. I mean, go right ahead.
For paper, you could try different things.
Yeah.
You could put more emphasis on one, and then you get more chances of winning. So I think it is a relevant question.
Yeah, it gives you more chances.
No, it's an excellent question.
Okay, I think we can discuss that in the next coffee break. Sorry, but I think also Lenka wants to. Yeah, I just make it a quickie here. In fact, it's mainly on the question of exclusion, the period for exclusion. Why are you laughing then? I just want to say I want to do it in. So in fact, these are 2 cases. In fact, I would just remind you of this ECJ cases of 217, in which the court decided on a contract, and that the question was, what is the relevant event from which is calculated the period which the maximum period of for the exclusion. And in this case, the court said that if there is a cartel procedure, it's starting this period is starting with a decision of the cartel office, which in fact was against the opinion of the court who submitted this question, which was a German body. And now I would like to focus not on an ECJ court decision, but on a German court decision, which in fact put up this question again, but not concerning the exclusion ground of anti-discriminatory or anti-competitive agreements, which this was the exclusion ground in this case. In this case, it's a grave professional misconduct, which was the exclusion ground. And in connection with this, the German court, in fact, it was the procurement of assault rifle, which is a case which went up and down. And in this case, it was argued that the other bidder must be excluded because in 2006 to 2009, he had committed some misconduct or some infringement of export control law. And in this case, then the Higher Administrative Court of Düsseldorf, Higher Appeals Court, decided that the relevant event, yeah, I can go to this position, the relevant event is not the decision on this violation of export control law. In that case, this was also a criminal procedure. It's in fact the misconduct, the end, because it was in a certain period of time. At the end of this misconduct, which is the cause for this violation, is the relevant situation from which it counts the period, the maximum period of exclusion, and expressly saying normally we would ask him to submit this to the European Court of Justice, but he said no, it's not necessary because it's a different exclusion ground, so we can decide ourselves. And in fact, implying that for the decision of the European Court of Justice, there is no substance for this in the provisions. That was more or less the judgment in this case, and the relevance for practice is quite high, because you could also see from this case here, it takes often very long until you get a decision of a cartel office or a court on a certain misconduct, so that often these maximum periods may be expired already very fast. But this is a question. And here I would say I have some, because not only because it's a German court, I have some sympathy for this interpretation of the question, what is a relevant event? Because in fact, I agree that the rules, they don't give any basis for this interpretation by the European Court of Justice. At least that's the developments, at least in Germany, on this European issue. I leave it with that and would like to say and ask whether
we have a question online from Suzanne. Based on procurement law, there shall be a transparency obligation. Why will the offered prices not always shared after an award is given?
This is a quite different question. Yeah, I mean, in construction contracts, it's in Germany at least, it's you have a public hearing where you can get the contract prices, but in fact, the idea is behind it because it's a business secret, I would say. So
in open procedures, the prices are read out at the opening, aren't they?
yeah, but only with construction contracts, at least in Germany.
And not everywhere.
It's the same in the Netherlands. They're being developed, but it's strange only to use in construction projects and not in other projects.
Yeah, in fact, German procurement law is the core of German procurement law is construction contracts, and that's how it was invented, and that was practice, and that I think it was the idea. So, any more questions? If not, Lenka, the floor is yours.
Thank you very much. So I wanted to say I have 1 minute left, but I'm really fast, so I'll try to be quick as well. Yeah. So now we move to the next step of procurement procedure after selecting the procedure, and after excluding the bidders. If there are still some bidders left, we come to the last stage of a decision award. Here you can see the articles relevant for award decisions, and the case which we are going to discuss today deals with the last article. Is relevant to abnormally low tenders. The directive says that contracting authority shall require explanation on price or costs proposed in tender where tenders appear to be abnormally low. This is the decision which we are going to discuss. Again, it is from Bulgaria, which is quite active in this field. What happened there in Bulgaria? There was a restricted procedure for services relating to operation, supply, management of ID cards, identification cards in Bulgaria, quite large tender, and 2 bids were received. The unsuccessful bidder, which was this company Veridos, challenged the contract award and claimed that the successful tender appeared abnormally low, and that the contracting authority had failed to verify whether it was abnormally low or not. This was rejected by the national authority because in Bulgaria, in their law, the legally defined evaluation criterion is objectively non-applicable, because Bulgarian regulation states that if the bid is more than 20% lower than the average of the remaining bids of other participants, then the contracting authority should require a detailed written justification of how the bid was prepared. But in this case, there were only 2 bids, which means that it was not possible to state like the average of those remaining bids. So what happened and what the European Court of Justice stated? The court said that the contracting authorities must always assess whether any tenders appear to be abnormally low, even in cases when the contracting authority doesn't intend to reject the tender, and also that the thing that there is no possibility to do this evaluation because of the national law is not the reason for not evaluating or not assessing the abnormally low price. So the court said that
If it was not possible because of this 20% provision, then other supporting arguments or criteria should have been used, such as estimated price or estimation value, experience of the contracting authority, or other provisions. The further point which the court stated was that if the contracting authority didn't find the price or the tender abnormally low, that in that case there are no obligation of the contracting authority to adopt a decision or state reasons if the winning tender does not appear to be abnormally low. However, and that was the last point which the court stated, the assessment of the contracting authority is subject to judicial review. The contract award decision may be challenged by claiming that the successful tender should have been classified as abnormally low, but at the same time, ECJ states that the lack of any statement of reasons for accepting a tender that did not appear to be abnormally low cannot lead to the annulment of the procurement procedure. This follows from the fact that simply there is no obligation to state reasons. So, and what are the implications for practice? Like for contracting authorities, they should investigate all tenders that have the appearance of being abnormally low, no matter whether the contracting authority plans to reject the tender or not. Also, they should make clear records of their assessment. However, if the outcome of the assessment is that there is no abnormally low tender, then the record for the assessment doesn't have to be like recorded or written, although it is recommendable. For tenders, this judgment may encourage more challenges by disappointed tenderers who could suggest that the contracting authority failed to assess whether the tender was abnormally low or not. It is we could recommend the tenderers to keep the records how the price was calculated and all aspects of calculation of their price, so that if they are asked for clarifications, they could submit all the documents within the requested deadline. Yeah, that's it from my side. And if you have any questions.
Any questions?
I guess you can speak loud enough. It's more.
No, it's also for.
Yeah, a question to the former part of Christian. I was wondering, based on the ground for exclusion due to part misconduct, is there any maybe German decisions or literature which is on the question of whether any misconduct by an individual person should be attributed to a bidder as a legal entity? Because I understand that guess it's similar in German law. If an individual person as a natural person acts against criminal law and rigs procurement procedure, this will be attributed to the legal entity as a whole. That's the fact. And then the whole entity has to prove that they have taken self-cleansing measures and so on. But maybe is there a decision which is more liberal on that, because in the cases where an individual doesn't work anymore for this legal entity, then I think it's a little bit unfair or really unnecessary to put them on the consequence that the whole legal entity is to be excluded. And when the person even doesn't even work there anymore, then they shouldn't be sanctioned with this punishment. Is there any decision on that?
As far as I know, no. But it's only attributable to the company if the person acted as a part of management or a supervising body. And that, I think that's also European law. And but then it's perhaps easier to demonstrate that self-cleaning, because if this person, then you have already the personal measure taken, which is one of the reasons why you can get self-cleaning, but also the other issues, because often it's not only one person involved, and then the structures must also be. So I think in Germany there is no decision I'm aware of. It's self-cleaning you must doing. But there's no decision saying that in such a case, if this person is not in the company anymore, that it's not attributable anymore to the company.
Okay.
Is there anybody from Germany who has another idea, or any other country? So
yeah, there's a ruling in the Netherlands stating that if you are part of the sales team, we had a case in which someone made up a false reference project. So he was not in management or whatever, but part of the sales team. And then because he operated within the lines of his job description, which was of course doing sales, not making up false references, but this participant was excluded from the tender. Yeah. So we have rulings in the Netherlands.
okay. So I don't accept any more questions because now it's a coffee break.
We can ask, should we carry on, or because we're running late, 15 minutes, do you want to carry on? Because if you want to finish on time and have drinks.
Yeah. Well,
it was a very good argument.
Rather in favor of carrying on, and then
I would say it's a good idea. You think so too? The next panelist?
Because then we can enjoy the evening and drinks even more.
No, I would say 5 minutes. No?
Yeah,
5 minutes.
But quick drinks,
yes.
And then we back.
You know, for all the needs you have. And see you in 5 minutes, but we will start in 5 minutes. We will not wait.
Last but not least, we thought that we have to speak about a quite actual and hot topic because, as you might know, the foreign subsidy regulation in the EU has been adopted a while ago, but its implementation regulation has been adopted quite recently in July. And this regulation will now enter into force with quite a few obligations for bidders on the one hand and for contracting authorities. And given the fact that these obligations, well, they kick in as of October, well, we thought a quick reminder would be nice, would be helpful. And yeah, that's why the last topic of today will be on EU foreign subsidy regulation. If you see FSR, you know what it means now. Right, Sven, you start the presentation, I think. Here you are.
Yes, thank you very much, Virginie. A warm welcome from my side.
Click, I click.
If I may introduce myself quickly, my name is Sven Brockhoff. I'm a specialized lawyer since 2013 in the Stuttgart office in Germany, so not too far away from Frankfurt. And I would like to give a quick overview over the FSR. Yeah, maybe first of all, what is the FSR about? The FSR closes a gap in the EU regulation regarding subsidies in connection with public procurement. Before the FSR, the state aid law, the EU state aid law, was and is very strict on state aids given by EU member states, but there's no rule or no regulation on subsidies originating from third countries outside the EU. So this gap is to be closed by the FSR. With regard to public procurement procedures, this is important because before the FSR, an unduly advantageous tender, or one case of such exclusion is relevant if the EU or the tender has received a subsidy which is unlawful to EU state law, and the FSR tends to close that gap regarding subsidies given by third countries. As Virginie mentioned, the FSR constitutes some quite heavy and severe obligations for companies which are challenging. We will look at that later. Maybe first of all, regarding the timing, the procurement procedures must be initiated after 12th July. Only then the FSR can apply. And furthermore, the reporting obligations only apply for companies from, or will apply from 12th October. So that's in the future, but procurement procedures initiated before 12th July can be carried out as they were, and the FSR does not apply for them. A few words to the term foreign subsidy. It is defined in the FSR as financial contribution, which is directly or indirectly provided by a third country, meaning outside the EU. As I said, this can be Switzerland, Norway, United Kingdom, but the elephant in the room is China, of course. The FSR has been drafted because of complaints of companies about bidders who have advantages or benefits originating from from the Chinese state, and this is of course the political reason why we have the FSR now, in my opinion. Two further conditions regarding the term of the foreign subsidy are the benefit an undertaking has in the internal market, of course. This is the legal reason
which is referred to here. And the third one is then it must be limited in law or in fact to one or more undertakings or industries. However, these conditions are not to be examined by companies. Companies have to report all financial contributions, if the FSR is applicable, of course, have to report all financial contributions to the EU Commission, regardless what they think about the 2 bullet points below. Yeah, that's up to the Commission to decide whether they are met or not. The financial contribution can be, to sum up, anything. Anything is what is beneficial in economic terms to the company, can be money, transfer of funds, liabilities. So it's a very wide term, which makes it even more challenging for companies, of course, because they have to monitor all their trades and whatever they gain or get from third countries. The financial contribution, this is no surprise, must be provided by a third country, meaning not every legal entity in the third country, but of course the government, contracting authorities, public authorities, even public entities, if they can be attributed to the state, which is, I think, almost in every case. And also private entities, if they can be attributed to the third country, taken into account all relevant circumstances. I think of a case where a private entity is controlled by a third country government, for example, or maybe has exclusive rights given by the third country government. And in this case, it is a third country subsidy within the meaning of the FSR. Some good news, there are some exceptions in the FSR as well. The first one is a case where the contribution, the financial contribution, is given with the aim of making good the damage caused by natural disasters or exceptional occurrences. In such case, however, it is not the decision to make by the bidder, by the company, to say, okay, this is the case here, I don't have to report that. No, it has to be reported, but the Commission then examines the contribution and can decide, okay, this is an exception here, this doesn't distort the internal market and is therefore irrelevant under the FSR. Then some real exceptions. The FSR is relevant for industries with high value contracts. For example, construction, energy, traffic, but not for the defense and security sector. It doesn't make sense here to apply the FSR, so this is an exception. A further exception is applicable if a negotiated procedure without prior publication due to urgency is carried out, and also if such procedure is carried out due to a standalone position. But in this case, the FSR is still applicable, but with the change or amendment that the reporting obligation is directly to the EU Commission, so the company has to report directly to the EU Commission and not, first of all, to the contracting authority, so the contracting authority is not in between. Further good news, the FSR is only applicable for very high valued public procurements. The value must be over 250 million euros. If the public procurement procedure is divided into lots, then the lot specific threshold applies of 125 million net. Only if this threshold is reached, the FSR applies. If this is the case, however, all financial contributions must be reported if the financial contributions of third countries extend to more than 4 million per third country, so aggregated. And If this threshold is reached, everything has to be reported. I didn't say during the 3 days prior to the notification. This is the bracket of it. Yes. One further challenge for companies is that not only their own financial contributions have to be reported, but also financial contributions their subsidiaries or holding companies have received, and also, this is a new term, main subcontractors and main suppliers. What is meant by that? Main subcontractors and main suppliers are such subcontractors and suppliers which contribute more than 20% to the value of the bid in question. So this is the threshold for that. Of course, for companies, it does mean that they have to monitor their subcontractors, their suppliers on a regular basis, which they maybe do not at the moment, in order to be flexible if they want to participate in a public procurement procedure which arises or is published, then they have to be flexible and gather that data and transfer it to the EU Commission. So that's quite a challenge for them and quite a burden, I would think. One good news in this respect is they are not responsible for the content of the data they get from their subcontractors or suppliers. So in terms of fines, penalty payments, they're not responsible for the veracity of it, but they of course have to collect their data and transfer it with their own data to the EU Commission. Yeah, thank you. Now Virginie continues.
Thank you, Sven. There is a difference in the regulation between notification and declaration. Well, the notification applies when in a procurement of above 250 million, the thresholds of the contributions are met. So if in a contract above 250 million, a tenderer has financial contributions from third countries above 4 million per country, well, then it has to make a notification. And there is a specific form, we'll get back to that, in the implementation regulation that they have to fill. Right. The FSR says, and that was a bit frightening, I must say, in all other cases, so it was where the conditions for the notification of financial contribution thresholds are met, economic operators shall notify the contracting authority, blah, 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 financial contributions above 4 million per country. In all other cases, and that's why I quote, economic operators shall list in a declaration all foreign financial contributions and confirm that they are not notifiable. So at first hand, when we read this, and a few clients of us as well, without having read the implementation regulation that didn't exist at the time, we were a bit frightened, because in all other cases, it could mean that this declaration obligation would be applicable in any procurement procedure, even a procurement procedure of a value of 100,000 euro or 30,000 euro or 5,000 euro, meaning that you would have to fill this form declaration with all the financial contributions, contracts, etc., that a firm would have outside the EU, because it goes quite far, the financial contributions. Even the price of a contract is a financial contribution. So the company would have to list that for itself and for its subcontractors, main subcontractors, for any contract, because it's in all other cases when the thresholds are not met. So we were a bit frightened, and quite a few clients as well. Some companies went to the European Commission and well, because they thought, well, this cannot be the meaning of the Commission to impose that on any small contract. That would be crazy. The idea of FSR is imposing these obligations for big contracts, huge contracts, where you don't want to have a distortion of competition. And indeed, it was not the meaning of the Commission, but it was written in a way that you could understand that in all other cases, when no thresholds have to be met, a declaration is still needed. And the Commission, well, I think clarified this point in the implementation regulation, fortunately. And in the implementation regulation, it's written in Article 5 that it's only in the contracts that are above the value of 250 million or 250 million plus 125 per lot, that these obligations apply. But so this was only clarified in the implementation regulation that was published in July, so quite recently. Before, during 1 year, this gray zone of what do they mean by in all other cases existed and was a bit, caused a bit of, difficulties for some clients. Anyway, so now this is clarified. We could consider that it's a contradiction between two documents, but anyway, let's say it's clarified. And so that means finally that you have to make a notification if you have financial contributions above 4 million for big contracts. And if you have financial contributions that are lower than 4 million, you have to make the declaration, not a notification, but the declaration. But anyway, two types of obligations are mandatory. Notification on the one hand and declaration on the other hand. Oh, I didn't take the clicker with me. It's here. Right, in an open procedure, you have to do it once. Of course, you submit only one document with everything in it, so you submit it at that moment. In a two-phase procedure, meaning competitive procedure with negotiation, blah, 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 all these two-step procedures, you have to submit this information twice. Once in the request to participate, and the second time with your tender, updated version with the tender. So a bit heavier in the two phases procedure. What shall the contracting authorities do as from now? Well, for these big contracts above 250 million, well, first they shall ask for this notification declaration in their tender documents, because not all the firms are aware they have to provide that. So I think, especially at the start of these obligations, the contracting authority should be quite well, they should explain to the tenders, to the bidders, what they have to do. So ask for the notification declaration. Second, when they get these notification declarations, well, they have to transmit them to the European Commission. It's not the contracting authority that will assess if there is a distortion of competition. It is the European Commission task. At the whole beginning of this idea of organizing a FSR regime, the Commission thought that the contracting authorities would make this assessment themselves. And this was submitted to expert groups of the Commission, etc. And all these people said to the Commission, no, 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 please, no, don't. Because if a contracting authority has to assess if there is a distortion of competition, it's quite a heavy work. Not all the contracting authorities are equipped to do that, because at that time the thresholds of the contract was much lower. So, I mean, we thought this is really a burden for the contracting authorities. You should have a specialized service that takes care of that, EU Commission, and that has that they would have like a common interpretation of the rules. So it should be your task. And fortunately, the Commission listened to that, and indeed, they decided that it would be their task to analyze whether there is a distortion of competition or not. The contracting authority, once it has submitted the whole stuff to the European Commission, can continue the procedure. So they don't have to wait until the Commission render its decision to continue the award procedure, but they cannot award. So they can continue the process, the analysis, the questions, etc., but they cannot award until the Commission has either rendered a decision or let the time limits elapse. And fortunately, the time limits are relatively short. It's 20 plus a possible extension of 10 days, working days, for the preliminary review of the European Commission. And if the Commission continues and goes to an in-depth review, it has 130 working days to do its in-depth review. That's quite long because it's working days. But at the same time, these contracts are 250 million contracts. In general, it's not like contracts that are awarded in a few weeks or in a few days. But still, yeah, the second time limit is quite long. Anyway, what if the notification or the declaration of the tenderer is missing? What happens? Well, first, the contracting authority shall ask for the missing documents. So that is foreseen in the regulation. Please, as a contracting authority, do not reject directly the tender. You have to ask for the missing documents within 10 working days. So the tenderer has to submit that within 10 working days. And if the tenderer still does not submit these documents, well, the tender is rejected. It's a cause for irregularity of the tender, and the contracting authority shall reject the tender. So the sanction is quite heavy. That's what Sven said before. I think especially at the start of these new obligations, tenderers should really be prepared to monitor their own contract subsidies, tax arrangements, any financial advantage or contribution they might have given by third countries. And they have to ask to their subcontractors and suppliers to also monitor that and to have all this information ready to deliver to the contracting authorities. We said with Petra, once this first initial work has been done, afterwards it will probably only be a case of monitoring, updating the list. But this list has to be made, and at first it's quite a big work for companies. We have had a lot of clients saying to us, oh, this is a nightmare because, we are an international, multinational group. It applies to the whole group of the company. So if the company has contracts everywhere in the world, well, this has all to be listed, monitored, etc., etc.
And also for the declaration, you have to monitor not only from third countries, but also from, all foreign countries. That seems to involve everything, not only third countries, but everything.
Yeah, indeed.
That's a difference, right, between the declaration and notification.
Yeah, and the declaration applies to any value of contracts. It applies only if the procurement at stake is above 250 million, but it involves any financial contribution received by the company. So that's quite heavy. It will be quite a long list for companies to make up. Right, the Commission will receive all these files. I suppose they will have a dedicated service for that. That will be probably a bit drawn in the first weeks. But what can they do? Well, they will investigate whether with these financial contributions there is a distortion of competition in the procurement at stake or not. The Commission can ask for missing information or additional information. Again, if the tenderer does not answer to that request, the tender shall be rejected. The Commission can also start itself an investigation if it has suspicions that there is a distortion of competition with financial contributions, even if the thresholds are not met. So the Commission can find by herself, there is a problem there, I will ask for a notification, even if actually the notification is in that case not mandatory. So the Commission can start any investigation. And we will see afterwards that any natural or legal person can fill a kind of complaint or ask to the Commission to start an investigation. So another tenderer that suspects that one of its competitors got some subsidies or financial help given, for example, by China, could file a complaint with the Commission and say, well, please look at this a bit closer, because I think that my competitor got an advantage that I cannot offer. And it's also closely linked to abnormally low prices, because the result of that often is that this firm will submit abnormally low prices. And it's to avoid that that this investigation will start. So what can the Commission decide, Petra?
Yeah. So after this investigation, there's different things the European Commission can decide to do. Firstly, if the Commission finds that there is indeed a distortion of the internal market, the first thing they can do is they can ask the participant in the tender to fully and effectively remove the distortion from the tender. That sounds great, but it's a little bit difficult to think about what that might mean, because at the same time, the foreign subsidies regulation makes it clear that you cannot modify the tender, of course, by any means. And at the same time, the tenderer cannot alternate its bid also. So that leaves little room to maneuver, I think. But you have some clarification in the foreign subsidies regulation. For instance, that you might give access to other participants in the market on the same terms that you can use, for instance, certain infrastructure or something. You could also maybe lower your market activities in other sectors. So there are some possibilities mentioned within the regulation itself. And if the European Commission finds that it's okay, the measurements you suggested, then you can go ahead and come to an awarding of the tender procedure. If the undertaking is not sufficient in its clarification, then the European Commission might come to the conclusion that the award cannot be, the assignment cannot be awarded to these participants, and then you would have to go to the next in line, so to say. Another option is that indeed the European Commission will come to the conclusion that there is a breach of competition, but that at the same time there can be some positive effects. And if the positive effects are, if they weigh more heavily than the distortion of competition, then they can adopt a no objection decision, and you can still go ahead with the tender. And then finally, and I would say that would be the most likely scenario, maybe at first, if the time limit, it's quite a short time limit of 20 days, if that time limit elapses and nothing happens, then you can also go ahead and award the tender procedure. Now, it's, as Virginie already said, it's quite important that participants in a tender realize this huge implication this regulation has, because there are quite impressive fines, actually. So if you hand in information, whether you do it intentionally or if you do it, not on purpose, you can get a fine to a max of 1% of the aggregated turnover in the last year, which would be quite frightening, in my opinion. But it would be even worse if you failed to give any information, because then the fine can, lead up to 10% of the aggregated turnover of the last year. So I would suspect that our clients would be aware of this already, and I talked to Virginie. One of our clients is participating in a tender process with an estimated value of over 250 million. it's not quite clear if they meet the threshold of 4 million, but so if it's a notification or a declaration, it's not entirely clear. They have to submit their bid somewhere in October. So we gave them a call and said, do you know the foreign subsidies regulation, and are you aware of all the documents you have to, draft? And they never heard of it. So they are now, as we stand here, quite busy gathering all sorts of financial information. But at the same time, to make it a little bit more easy for participants in the tender process, you have a draft form you can fill out. It's an annex to the regulation, and it's quite clear what information you should come up with. I think much of the information is quite easy to, like what's the name of the procurement and who's the procuring entity and such. That's all fine. But then look at section 3 specifically, because there you have to, come up with a full list of all financial assets that might be relevant. I think that's a huge thing to complete this section 3. But also section 4, so you have to justify for yourself why the financial contributions you received do not form any distortion of competition. So I would say you would need, someone like Volker says from CMS to help you out there. And then some other, you have to, provide some evidence documentation, etc. That's all fine. But the more relevant thing, I think, is that even if you don't have to hand in a notification, but a declaration, you still have to use this form. And you still have to fill out the sections 1, 2, 7, and 8. It says 1, 2, 7, and 8. I think you also have to include a description of financial contributions you've received from not third countries but foreign countries, as the so that remains a lot of work. So then, of course, a very important question: do tenderers have any rights? Well, of course they do. If you are a competitor, you can report to the Commission. If you have any relevant information, you can go to the Commission and ask for an intervention. I suspect that this will be quite a frequent route that participants in the tender process will take. If I look at clients from the Netherlands, they know their competitors quite well, and they also have quite a clear view of who is being subsidized by, maybe, let's say, China. We have for instance, in bus concessions, we have a lot of Chinese buses, electrical buses, and in the Netherlands, there's a lot political resistance against the involvement of those parties. So I can imagine that would be something to report to the European Commission. You are also entitled to files at the European Commission. So you, as we read it, you can see on the basis of which information the Commission comes to what conclusions. And of course, if you are being excluded from a tender process, you can object in the national courts. Specifically, it's specified in the foreign subsidies regulation that in cases that there is any unclarity about the foreign subsidies regulation, the national courts should address the European Court of Justice and ask for guidance. At the same time, you can also, of course, object against any decision made by the European Court of Justice, the European Commission, and you have a time limit of 2 months to object to any decision from the European Commission. So we'll have to wait and see what happens if there are any, really firm decisions by the European Commission, and we will also have to wait and see if national courts are willing to you know, overlook any ruling of the European Commission. I don't think they will do that lightly. That was it. Oh, so this is a little bit what you explained earlier, Virginie. So what do you have to do? Well, as a participant in a tender process, you might want to start, you know, drafting documents right about now. And once you've come up with the first draft, I think it's more or less a case of reviewing it on a monthly basis. In the Netherlands, you see a lot of accountants that are quite active and advise clients. I think they're quite logical party to do it because they have access to the financial situation already. And you have to be aware not only of the notification, but also of the declaration. Yeah, the contracting authorities, as Virginie said, I think a lot of tenderers, they need some guidance and some explanation. And also, I think it would help not to be too firm in the beginning if people are too late with the documents or they're incomplete, for instance. I think it would help to, you know, give them a little bit room to get comfortable with the obligations. Of course, very important, you have to wait with the award of the contract until the European Commission has come to a conclusion. I think when you have the bigger contracts and there would be an in-depth interview of investigation taking 130 days, I think that would be a huge issue. If you look at the way prices are evolving now, it would mean 3 or 4 months, right? Extra waiting time. So if I was a contracting authority, I would look at my financial regulations in the contract and see how you deal with the price issues during that time, because 3-4 months is for participants in a tender really huge.
It's even more because it's working days.
That's working days, so it might be yeah, almost half a year maybe. Yeah. And then finally, of course, if the European Commission feels that there's an infringement of competition law, you would have to reject the tender. So big stuff, and let's see what happens. Any questions on this new topic?
We have a question on GoToWebinar. Which court is competent for the decision of the EU Commission itself? We ask ourselves the question just before giving this presentation.
Ben, I said, didn't you say the European Court of Justice, or maybe the Court of First Instance?
We didn't have the time to check it.
On the slide, I think it's the European Court of Justice.
Yeah, on the slide it's the European Court of Justice.
Yeah, it's here.
Yeah.
So it should be that, but we didn't have the time to double check, but it should be the European Court of Justice, yeah.
Yeah.
Yeah, well.
Is there a mic? Very short question.
Very short question. Is it possible to extend this 10 working days period for the request of the information?
For the contracting authority?
Yes.
I would believe so.
I think so. Just check with the regulation, but I think so.
Because in fact, if you prepare it and then you have some competitors who are not so are more reluctant,
yeah,
it might not, you might not.
But I
like
think,
that.
yeah, I understand. But I think, given the fact that it's new regulation, any contracting authority being friendly and saying, "Oh, you need 5 more days, take 5 more days," I wouldn't believe any judge would say, "Oh."
The Commission may extend the time limit by 10 working days once, it says in Article 30. So it should be the answer.
But only once.
Only once.
Yeah, that's the time limit of the Commission to render its decision. But I think you were talking about the working days for the tenderers if they have to complete the documents. Well,
I don't think I've read something forbidding a contracting authority to be reasonable, because that's what
It says it can request that the economic operator completes its content within 10 working days.
Yeah.
So
It's
So
not talking about an extension or minimum or maximum 10 working
a
days.
competitor could always say you have to give 10 and not 15 days, because that's unfair.
Yeah, the FSR regulation sounds quite.
yeah, that's fine.
10 days, yeah, indeed.
We have more questions.
Okay, in case of group or company biddings, will the consortium leader be responsible for the filling of the FSR check documents for all the entities of the consortium? Well, yes, at least the FSR or the implementation regulation says that the prime contractor is responsible for filling it for the subcontractors and suppliers. But I suppose it's the same as if it's submitted by a consortium. The leader is responsible to collect.
But in the end, it doesn't matter who is responsible, because if one of them doesn't supply,
yes,
then of the consortium agreement.
I just continue the
no,
question.
that's internally, but externally.
Same for the main contractor in the relation to the subcontractors. Yes.
Yeah.
Can this responsibility be transferred to another consortium partner actually via articles of association? Will the responsible entity for the FSR filling be also liable for indirect data? No. So that's quite clear in the regulation that the main contractor or the consortium leader or any person of the consortium that takes the lead on this is responsible for collecting and submitting the information, but they are not responsible for the content of the information of the others. They are only responsible for the veracity of the contents of these documentation for themselves.
Yeah.
They are not responsible for the others. They just have to collect and submit.
Yeah.
And each of these entities is responsible for its own content. Will the contracting authorities define the time frame for submission of FSR documentation? Well,
I would hope so.
Well, yeah, but it's also written in the regulation. So for the two-step procedures, it's one time with the request for participation. So the deadline is the same as submitting the request for participation. And then at the second stage, it's with the tender. So it is with your main documents, with your other documents, that these documents will have to be submitted.
But in tenders I've seen so far, that the procuring entity includes it in the tender documentation.
Indeed.
As something to submit.
And that's what's foreseen in the regulation.
Yeah.
Okay, thank you.
Okay. I can have that.
Thank you, Becca. I have two questions for you. The first one is, if the financial contributions are below 4 million, then a declaration has to be filed regardless of the amount of the contributions. For example, if it's 10,000 euros, then
yeah, it seems so.
Okay.
Yeah.
And the second question is, as the contracting authority shall request to the tenderer to submit the document if it's missing, then how can the contracting authority guess that it's missing? Because how can it guess that the tenderer should have filed either a declaration or notification if the information is not?
Well, either the contracting authority or the commission have suspicions, and then they will ask for the missing documents, or they have no suspicions, and another tenderer could warn these entities and say, hey, I think he should make a declaration or notification. And if no one sees it, well, then it goes below the radar. But that's why there are quite high fines if you don't do it, and you had to do it, because the aim of these fines is that people will not rely on the fact that the contracting authority and the commission will not see it and will not react. Well, if you try that, you have to be very brave, because if it doesn't work, then the fines are quite high. Or very rich.
Yeah.
Because 10%, if the documents are missing, totally missing, it's 10% of the aggregate turnover of the group in the last financial year. So, I mean, if it's a big group of companies, it's quite a lot.
Could you get back to the definition of the financial advantage and what is a subsidy? Because it's very wide, if my understanding is correct.
Yeah.
And could it cover a contract with a foreign state?
Yes.
Yeah.
It does cover contracts. And
So
public
it's
procurement.
not a subsidy.
No, it's not a subsidy. It's a lot larger than just subsidies.
So
it covers prices of contracts that were awarded in a regular manner to these companies.
So if you have contract with a foreign state,
If you have a contract with the UK,
you have a normal activity.
you have to report it.
Yeah. So everyone has to report.
Yeah, it's not just subsidies, actually. The term is probably a bit misleading.
Yeah, it's completely misleading, I think. And for our clients, it's completely misleading.
It is, yeah, because they think
And it's not only China.
No, indeed, not at all.
Yes.
Yeah, US.
And second question, I didn't completely understand the enter into force. If you have a publication in July, and then you have to fulfill in October, or how does it work?
I think, if I understand it correctly, if it's published after the 12th, I think, or somewhere in July, yeah, if it's published after that date, and you have to submit your tender before the date in October, then it's fine. You don't have to do anything.
Yeah,
The European Commission can conduct an investigation. That's
Yes.
the only thing you can do there.
Yeah, the European Commission can ask for something, but
Yeah.
you do not have to proactively submit anything. But if the notice was published after this date in July, and you have to submit your tender after this date in October, then you have to proactively submit the documents.
We have one more question in the chat. Does the obligation to file FSR information apply only to the participating companies, i.e. if the parent company is not participating, the data for the latter shall not be submitted?
No, if a participating company has to notify or declare, they have to notify or declare the contracts and financial contributions of the whole group. So even of the mother company, for example. So it's really large, actually.
We're looking at it in disbelief.
I just have a little last question, also to you, Petra, as you have referred to the decisions the Commission can take, and the one is, as I saw that maybe you can go there back, that she can ask the bidder kind of to repair the distortion. That's the first alternative. But the initial tender should not be changed, which is quite clear because, for example, in an open procedure, you may not change the offer at all. So, but what does that mean? That would mean there's only one way for the bidder to do without the subsidy, or what else? How else could it be done?
I think because the answer is in the regulation itself. I think in Article, was it 7 or something?
But it's indeed a difficult
It's explained in Article 7, and it states that you could, for instance, refrain from certain investments, reduce capacity of market presence, offer access under fair, reasonable, and non-discriminatory conditions to the infrastructure, etc. So they have quite
Does that
specific.
Does it help? It's too late.
Sorry?
Does it help? It's too late.
No, I don't think so necessarily, because the European Commission believes that you could have an advantage from a loan you received, but the relevant question is, does it lead to a distortion of the market? And if you have other means of repairing the balance, then it's okay. So it's not too late, apparently not, because they see all kinds of opportunities for you to address the issue. So it's quite an elaborate list of possible.
Okay, thank you. So if there are not any more questions, I think we could come to an end. So maybe you make a wrap up. Okay.
Yeah, well, I hope you could take some takeaways from. I don't know if it works. No, you could take some takeaways from these presentations. We had first very enthusiastic presentations on opportunities and good examples of using ESG criteria. Find it always very difficult, and sometimes I'm a bit depressed when I have to use them because I don't feel that I have a good way. But Natasha gave us some good examples and best practices, and I found that very, very positive. So thank you for that, Natasha. After that, we had a slightly more frightening presentation with do's and don'ts, big do's, big don'ts from the Jacobs. Okay, sorry, Mark and Julia. Thank you for that. And then we had this very sexy presentation of Eve, Christian, and Lenka, during which Christian even proposed to do it quickly. Thank you, Christian. Did you notice? Well,
interesting comment.
It was funny. But it was not quick. That quick in the end, I must say, but still very interesting. So thank you for that, Christian. And finally, well, this last subject, which leaves everyone very skeptical and very not so enthusiastic at all, but nevertheless, it comes, and winter is coming, so we have to be prepared. And well, finally, I think well, the last word comes and goes to our host, Jakob. Thank you, Jakob, for having us here. It's not over because we have our internal day tomorrow and our internal nights tonight. But thank you for having us here. Thank you for the preparation. It was really nice to organize that with you and with Christian and all the other members of the team. And I leave you the final word.
Yeah, thank you also to all colleagues and our external speaker, which was very nice to get such interesting insights, and also to the audience, also raising the questions from there. And so I'm left to invite you now to our final reception here. Maybe if you would like to take a little bit fresh air, you're also welcome to go to our terrace, and I recommend to walk around here, and we'll have a lovely look to the European Central Bank. But so that's it, and thank you very much.